Good afternoon, everyone, and thank you for joining us for today's webinar titled A Brave New World, Remote Execution of Estate Planning Documents. I'm Andrea Terry, the Director of Learning for the MSBA, and I'd like to thank the Estate and Trust Law section for the time and effort put into this program. As you all know, there's been a lot of demand and interest in this topic, and it's become even more important during this pandemic. We've got more than 200 people on the line. We had almost 500 people register for this webcast, so we really appreciate the efforts of our panelists today. If you have questions during the presentation, please email them to chriselle@msba.org, the email address you should see at the bottom of your screen. We cannot guarantee, obviously, that all questions will get answered today, but your faculty will do their best to answer as many as they can in the time that we have, and we have blocked until 2:30 to go with this presentation. So our panelists today are Leanne Broyles with Frost and Associates, John Lasley with Stewart, Plant and Blumenthal, Lynn Sasson with Gordon Feinblatt, and David Sessions with Frank Sessions and Beckett. So we're very grateful again for their time and effort pulling this program together. And thank you all for joining us. And I'll turn the program over now to Leanne.
Great, thank you, Andrea. And thank you everybody who is joining us virtually today to discuss remote estate planning document execution. My cat just bit me, I'm sorry. Remote estate planning document execution is a very important tool for us all right now. It enables many clients who are otherwise unable, either because they're sick or otherwise unable to travel, to execute important documents. And at the same time, it just keeps everybody a little bit safer by reducing the need for exposure. So I want to give a quick thank you to everyone who made it possible for us to do this, including Senator Chris West, the Governor's Office of Legal Counsel, and Section Counsels John Lasley, Danielle Cruttenden, and Ann Coventry. They all worked very hard towards getting these governor's executive orders passed. Although it's wonderful to have remote document execution as a tool, implementing it into our practices, as those of you who have done it will know, is quite a challenge and requires us to think through a variety of issues and also overcome technological barriers. It won't work for everyone, and it may not be the best solution all of the time. In this webinar, we're going to focus on working through the various requirements for utilizing the remote document executions and practical considerations for the same. We hope that hearing the four of us discuss these issues and respond to your questions will be helpful to the viewers. The format of the program is as follows. John Lasley is going to begin by providing an overview of the executive orders and Secretary of State guidance for remote witnessing and remote notarization. Lynn Sasson will lead us through issues and considerations leading up to a remote execution. And David Sessions will walk us through considerations during the remote execution ceremony. After this, I'll end with post-document execution issues. Following this, we are going to be treating you to a home video that serves as a sample of what a remote execution ceremony could look like, and we'll follow up with Q&A. We're going to be on the lookout for questions during the program to address them if they are appropriate. So if you have something that's relevant to what we're talking about at the time, send the question in. We might be able to address it then, or we will return to it at the end of the program if we have time. With that, I will turn it over to John Lasley.
Thanks, Leanne. Greetings, everybody. So in this new environment, we're operating under two executive orders that the governor promulgated pursuant to his powers under Title 14 of the Public Safety Article. So in those powers, he has the authority to suspend the effect of any statute, rule, or regulation of the state or political subdivision to the extent that is necessary to preserve the health of the populace. So that's the legal rationale for what he has done. The first of the orders to come down was Executive Order 20-03-30-04, authorizing remote notarizations. The order deals with remote notarizations generally, which is a broader category than electronic notarization. Electronic notarization is a subset of remote notarization, so please bear in mind that they are not co-equal. The order is not as stringent as Chapter 407 of the Acts of 2019, which will take effect on October 1st. So these rules right now are in effect right now. We're not quite sure what the interaction will be between the executive order and the new statute if the emergency remains in effect on October 1st. Under the order, the remote notarization is permitted if it is done using a, quote, communication technology, unquote, that permits the notary to view the signing in real time and to compare for consistency the information and photos on identification credentials. In other words, the camera on both ends has to be good enough for the remote notary to see a driver's license or something like that and to know who the person is. The remote notarization, so then after the technology is established, you have to actually do the notarization. The notary and the principal have to be able to communicate with each other in real time, both visually and audibly throughout the notarial act. The notary has to have notified the Secretary of State that he or she wishes to conduct remote notarizations and identifies the technology that they will be using to do that. That's a one-time notification and a general permission used for that technology. The notary then, during the process, takes the usual steps that they would take to identify the signer's identity and the documents being executed. Need to take the extra step to make sure that all copies of the document, if they're being one copy is being executed in one place, another in another place, are identical so that they're the same document, and we'll be talking more about that as we go along. Both the certification and the notary's journal must note that the notarization was conducted remotely, and the notary has to create or cause to be created a full recording of the notarial act, and the notary is responsible for retaining that recording. The guidance we have so far doesn't specify a length of time for that retention, but the upcoming statute requires 10 years. So I think that's probably the default setting for that. So those are the bare bones of the executive order. The Secretary of State has put some flesh on those bones through guidance issued on April 10th that superseded and expanded guidance that was originally issued on March 30th. The only additional requirement to the executive order that's in the Secretary of State's guidance is that you can't charge more than $4 for any remote notarization, which is the current maximum fee for allowed under the state government article. The Secretary of State recommends that remote notarization be conducted through full-blown remote notarization services, such as DocVerify or something like that. Those services provide for electronic notarizations, things like credential analysis, electronic stamps, and things like that. So they're much broader, they tend to be more expensive, and they're a bit more complicated to put in place. The revised guidance that came out on the 10th expands the universe of permissible technologies to include video conferencing platforms other than Zoom, which is specifically excluded because of the security issues they were having. If the technology provider is a vendor that has been operating in the US for at least 3 years, the notarization can be recorded and the recording retained, and the signer and the notary can, quote, immediately transmit, close quote, the document to one another. Transmit under this requirement is not defined. After discussing the practical implications of this and the intent of both the existing notarial law and the executive order amongst ourselves, we have concluded that a visual transmission through the video platform is sufficient to meet the transmission requirement. But each of you are going to have to come to your own comfort level on what is included in transmission. The Secretary of State's guidance lists some applicable vendors for both the full-blown notarization, some acceptable, vendors for both the full-blown notarization services and the video conferencing approaches. So that's a good starting point if you're looking for the kinds of things that will be acceptable. In many respects, the requirements are somewhat less stringent for the remote witnessing and electronic signing of certain documents, which is covered in Executive Order 20-0410-10-01. That executive order suspends the effect of Estates and Trusts Section 4102, Section 17110, and Health General Article 5602 to permit the remote witnessing of wills, powers of attorney, and advance directives. The remote witnessing is permitted if the testator or principal, as the case may be, the witnesses and a supervising attorney are in the quote electronic presence close quote of one another. Electronic presence in this instance means that everyone can see and hear everyone else in real time. There's no recording requirement under this executive order. So Zoom would work here, as would any other video conferencing service. Obviously, if you're going to be including a document that needs to be notarized in the process, then you're going to need to do the more stringent notarization types of services. The supervising attorney that I referenced, who's going to be, and we'll explain this more going forward, needs to be a Maryland attorney in good standing. The signer needs to be a resident or domiciliary of Maryland or located here at the time of signing. And the witnesses must be Maryland residents and located within the United States at the time of signing. Electronic signatures are permitted under this executive order. So DocuSign or something like that could be used in this instance. After the document has been signed and witnessed in the usual manner, the supervising attorney will create a certified copy by assembling all the pages of the document, including all the original signature pages, be they electronic signatures or wet signatures. We don't believe that a copy, such as a scanned copy of a wet signature, will work as an electronic signature. So that pardon me. So we think it's either just an e-signature or wet signature. The certifying attorney will certify that the copy is complete and accurate, that the signatures are either the original signatures or the e-signatures, that they took steps to verify the identities, residences, and physical locations of the signer and witnesses. And then that document, once assembled, will be the original document. The Section Council has prepared forms, example forms for those certifications, which are posted on the section right now on the section website, and we will be getting links out to everybody through all the executive orders, the guidance, and those forms soon, hopefully later in the program. Please, neither of these orders changes the other requirements of existing law. It's only the new things that are changed. So things like the number of witnesses, that the testator must be able to see the witnesses sign, all of those things remain in effect. So with that, I will hand over to Lynn for pre-execution issues.
Hey, John, this is David. I was wondering if I could just add something.
Please.
As I've been going through this, really what I've noticed is it really takes place just as a regular execution of a document. It just is done through online videoing. And so it sounds complicated, I think, with the executive orders and that sort of thing. But as I've really gone through it, it's kind of simple in that I do almost everything the exact same. It's just I'm meeting with someone over the video chat.
Right.
Thank you, John. So John has given us the legal background for the remote execution. I am now going to walk you through some of the processes, protocols, etc., that you need to think about. And while David just indicated that his experience is that it's fairly straightforward and you do what you usually do. You can't wing it. You have to have a process, you have to have protocols, and you have to manage the process. And what your process is going to depend on whether you're a solo practitioner, whether you're in a small firm, whether you're in a larger firm. And the reason I say that is you need to put together a team of people who are going to participate in this remote execution. And your team may be, as for all of us on this panel, people in your firm or in your practice group. And that's much easier for those of us who can do that. If you don't have access to a standard team, you need to, each time you're doing this, identify your witnesses, identify your notary, and have a set of protocols that will apply. One of the, as John indicated, the underlying law for execution of documents hasn't changed. So one of the issues that you have to think about is chain of custody. Unlike when someone's coming into your office and you have the document, you hand the document to the client, the witnesses are in your office, you are in complete control of that document, but before, during, and after the execution process. Here, you need to manage the process, but you're not necessarily in control of it. And you need to establish a chain of custody with the client, with the witnesses, and with the notary. And, how you do that will depend on, again, your type of practice, your firm, your team. But what you need to think about is how will you get the document to the client? In our firm, we've decided that we're going to send the original document either by regular mail or by FedEx or UPS, where we can track the delivery of the package. You also need to get those documents to your witness and to your notary. If they're part of your office, that's easier than if they're not. So you need to think about how you will transmit the documents. Other methods are the client may come to your office and pick up a package that you leave outside your office. Maybe you drop a package off outside the door of the client's house. Maybe you email the documents to the client. One of the issues with email that you need to think about is how do you ensure that the client didn't change the document. Now, if it's a big change, it may be very obvious because the pagination will be off. But if the client just sticks something small in there, you may not know. So you need to think about that. You also want to think about how those documents will get back to you, because as John indicated, you don't have an official document until the certification of the supervising attorney is completed. What we're doing in our office is we'll be enclosing a return envelope, postage prepaid, either for regular mail or a tracking service. And what I envision is when you conclude the process, you make sure the client has the envelope sitting right there and puts the documents in the envelope. Now, you can't guarantee what happens after you go offline, but at least you will see the client doing that. So that's sort of the chain of custody issue that you should be thinking about. The other, another issue to consider is do you need to make changes to your documents? And related to the chain of custody is the ability to identify the document. The client has to identify the document. The witnesses have to identify the document and the notary has to identify the document. So you want to have a clear, readable footer on your document so that you can ask the client what appears on each page. And if it's, as in my office, this tiny little document number, I'm not sure that's going to work for all clients, that you may want something much more visible, whether it's the client's name, the document, the date of the document, the version number, or some combination of all of those. But you need something that is identifiable on each page of every document that's being signed. For your wills, you should think about whether you want to change your attestation clause. We talked about it amongst ourselves, and one of us, it has changed the attestation clause to indicate that it's a remote execution as opposed to an in-person execution. Most of us haven't done that. That doesn't mean we won't decide to do it at some point, but it is an issue for you to think about. On your documents that need to be notarized, power of attorney, you do need, as John indicated, to modify the notary affidavit. It has to specifically indicate that it's not in the physical presence and that you used communication technology. So, be sure to do that. I don't know, everybody has a different practice for the information they require from witnesses. We always have the printed name of the witness and the witness's address, which is always our firm address. And so if you have your own team, if you will, you can pre-fill that information in, and then all the witness has to do is sign. If you are using witnesses that maybe you don't know or that come to the table late in the game, you will have to make sure that those witnesses fill in whatever additional information you desire to have them fill in. You should think about, some of us still have the client initial each page of the will. Most people on this panel don't. Our office still does that. But if you follow that practice, you need to think about the challenges of getting the client to initial each page when you're doing it remotely, since they invariably miss a page even when you're doing it in person, and you have to go back and have them initial. You need to think about whether for powers of attorney and advance directives, you want to have clients execute multiple copies, which many of us typically do when we're doing in-person executions. These are just things that add to the complexity, not because they're hard, but because you're not in the same room and you're doing it remotely. Technology is a big challenge. You need to understand the platform you're using. You need to test that platform and repeatedly test that platform, and you need to practice. We, in preparation for this, have used Teams, Microsoft Teams. What we discovered is that there's different functionality depending on whether you're on your phone, on your iPad, on your laptop, and you have different tools available depending upon whether you have set up the meeting or you're a participant in the meeting. You need to understand exactly what those options are and figure out all of the details before each and every execution. John mentioned, or maybe Leanne, I think, mentioned a video that you're going to see at the end. Well, We did one take for that video. We're not going to win any acting awards or directing or producing awards, but we did one take and it took 14 minutes. But we spent an hour beforehand figuring out the technology. One of us went from an iPhone to a laptop. One of us went from an iPad to a laptop. One of us went from a laptop to an iPad, and it really took a while to get the technology functioning. So you really need to think about this and practice and prepare your client and prepare your witnesses and your notary.
Can I just jump in for a quick second?
Sure.
Yeah, so I just wanted to share that, so most everybody else who's on the panel has been using Teams for the most part. My office has been using Google Meet. We're trying to switch away from it, but it also, I just want to emphasize that you really need to understand the limitations of whatever technology you're using. Ours in particular, the Google Meets only allows you to be recording one person at a time. So you have to understand, and it is possible to do, but you really have to play around with it and understand what you need to do to be able to create a video product that's going to meet the notary's retention requirements.
Len, you're muted. Just need to unmute.
Sorry. Thanks, Leanne. And just to follow up on the recording that the notary has to do on Microsoft Teams, the person who initiates the call is the only person, or the meeting is the only person who can record. So if your notary is someone in your office, that's fine. But if your notary is someone that you don't really know, or that you've retained to perform this service, you need to think about whether you want a stranger, if you will, to be controlling the meeting. Things to think about. The last thing I'm going to talk about is managing the process. As David said, when you do it, it's not that different from when you do it in your office, but you need to manage the process. Everyone needs to be prepared. As the supervising attorney, just like in your office, you are the point person, you are the coordinator, you are the communicator. You need to understand the remote requirements. You need to have your protocols and processes in place so that you can communicate them to everyone else that is participating. You need to prepare your client. You need to understand whether your client is tech savvy or is tech challenged, and you may need to do a rehearsal with your client. You may need to get online with your client before the formal session to make sure that everything is working properly. You need to explain to your client and to the witnesses beforehand what to expect. Because you are going to be asking your client to identify the document, to read you the footer, to tell you how many pages. And if the client doesn't expect that you're going to be doing this, you might run into some difficulties. Similarly with the witnesses, they need to know what to expect. Even if you're using witnesses from your office, most of them are accustomed to just coming in and signing on a page and then leaving when the process is done. Well, they now need to identify that their document matches the document that the client has, what page they're signing on, etc. With respect to your notary, as John mentioned, you need to submit your intent to do remote notarizations to the Secretary of State. I did that earlier this week and got back an acknowledgement within 24 hours. You need to talk through with the notary how the recording process will work and the retention of the recording. We as a group talked about whether you might want to record the entire execution process, and we all decided that we did not want to do that for the execution of wills or advanced directives. So in thinking about the order in which you do things, you probably want to do your power of attorney last so that your recording is at the end of the execution process. You need to think about who may or may not need to provide ID. If everybody knows everybody, you don't need to produce identification, but if the client's going to need to produce identification, you want to plan for that in advance so they're not running off to go find their driver's license. You have to repeatedly make sure that everybody understands these documents are not valid until they come back to you as the supervising attorney and you complete the certification. You need to monitor for the return of the documents. Just because you turn off the camera doesn't mean you're done. You need to follow up. You need to make sure if you're using mail with a tracking service that you track the documents. If it's regular mail, you need to follow up with the client and the witnesses if the documents are not back in a couple of days. You just can't say, we're done. Lastly, and David's going to talk about this in great detail, you need to have a checklist for execution. It may become rote after you do a number of them. We don't even think about it when we do it in our offices, but there are a lot of steps here and there's a lot of coordination, and you could miss something if you don't have a checklist. So, be sure to put together a checklist. And now I will turn it over to David, who is going to walk you through the execution process.
And Lynn, thank you for that. And I do like what you mentioned, that it can be straightforward if you are prepared, right? That if you are managing and you're ready for it, then it can go smoothly. But we've also, as we've been preparing for this, we've noticed that things can really be derailed, either if you have really slow internet or if the technology isn't working or something like that. You can run into significant problems. And one thing I wanted to add too is a lot of the platforms that we have a web browser platform and a standalone app platform, and that the usability between those two can vary as well. And so that's another thing, especially with clients, if they just click a link, sometimes it will take them to a browser, and it may not be as useful as actually downloading the app. I wanted to talk about some issues that arise with the execution ceremony itself when you're in the video for that 15, 20, 30 minutes actually signing the document. One of the things that we felt is probably the most important is simply the camera position. That sounds simple, but when we've been working on this, we find that it's probably very, very important that you see the entire person and you see the documents that they're signing and you watch them writing, right? Because again, if you don't see that, you don't know that they've actually put pen to paper and signed it. And I think that's one of the most important things that we can do. And that's where, depending on the device you're using, you run into problems. I myself have actually pretty long arms, but I realized with my cell phone, I don't have long enough arms to be able to capture the entire picture. And just because I see it on my computer doesn't mean that everybody who's watching sees the exact same picture. And some of the things that we've realized as well is even when we're recording it, what we see 4 boxes. Well, when it's recorded, those 4 boxes are switched around. And so I think it's really crucial to be able to see everything that's going on with the person. Some of the problems as well is the ability to view all parties simultaneously. Some applications have the gallery view, some do not, and that's can be problematic because if you're flipping between cameras and between people who are speaking, you may miss something, and you may not actually be able to watch them sign the document. Lynn touched on verification of the documents and making sure that you prepare them to be able to do that. In the video that we've prepared, you'll see that we simply verified the document by saying, witness one, I'm using Jane Doe. I have Jane Doe's power of attorney before me. Do you have that same power of attorney? In the footer, it says, version 2 or version 5. With the date or whatever identification you use, and going through that process with every person who is involved in the execution ceremony, so that again you're all operating on the same document, and then all those documents come back, and the attorney has to verify again that those are all the same document. I think we've all run into this, is where we're sitting in our office and the client says, "Nope, I've changed my mind in the last 5 minutes. I want to do something else, or I want to increase this bequest by $5,000." As we've been discussing, because of the preparation that has to go into this online execution, we think that maybe it wouldn't be great to suddenly change something and email them a new document, and have them print it off and have this new document. I think you could probably foresee the number of issues that may arise. Documents get confused, emails get confused, and you may not actually implement what happens, or what the client wants to have happen. As many practitioners do, I think still soliciting the declarations that from the client that do you intend this document to be your last will and testament? Do you want witness A and witness B to witness those documents, and making sure that you get affirmative statements from them as to that, just as many people do already. Again, it's just making sure that they confirm that they want that to happen. For the notarization, and again, notarization kind of falls in a different camp than just the witnessing, and the different applications apply differently, or the platforms that you use. But again, John touched on the transmission of the document. What we've found helpful is that when you're signing, you sign, with the video, you sign, and then you can bring up the document and show them, that this is the document that I signed. You can show them the footer again to confirm that everything is matching and they're signing the right document. We touched on the recording, making sure that the person who needs to record has the actual authority under the platform to push record and make it happen. I think one of the other issues that attorneys are used to facing is making sure that clients aren't being subject to undue influence, or that there's no fraud going on. I think many times we have a client that comes in with someone else, and you can kind of tell that maybe something fishy is going on. I heard one attorney who was doing remote executions, and they kind of turned it into a joke. Is anybody else in the room? And I think that may be really important to bring up, because maybe get a list and write in your notes that you asked, was anybody else in the room, and who was there, and maybe they left, or you had them leave the room so that the client was just in the room themselves for this process. Again, all those regular things that we do will be modified slightly, but making sure that you are, as Lynn said, in control of the process and able to understand what's going on the other side of the camera. The last thing that we wanted to touch on was the application of the signature itself, and this goes kind of more to what I said at the beginning, the camera position. Under the executive orders, you can use third-party platforms where you just click and sign. For example, Adobe eSign or Doc Verify, or there's a whole host of them. I think it was our general opinion that if you're using one of those, you do want to bring up, the second device that they're actually clicking on and show that yes, you're clicking. That I think, while the third-party applications are designed to ensure chain of custody and ensure that the person who is doing it is in fact clicking. As you think about it, if it's just an email, who has access to the client's email? Maybe their spouse, maybe their caretaker, maybe the laptop is left open or their desktop is open in an office and someone could just come in and click. And again, that's why we're supposed to be doing it in real time over a video. But I think the issue is making sure that they're the person actually doing it, and making sure that, again, the witnesses see the testator sign and the testator watches the witnesses sign. And that's where even you could do it via a touch screen or with a stylus, right? As you do at the grocery store with a credit card or something like that. I think that's also a doable thing, a doable execution under the executive orders. And then pen and paper, just making sure that the camera shows the entire thing. And once that's done, there are very important after execution things that should take place, and that's where I pass it to Leanne.
Great, thank you, David. Okay, so for post-execution issues, I think really the biggest thing is the supervising attorney certification. As my other presenters have explained, the documents that are being signed under the remote witnessing governor's order, they're really not fully executed until they are certified by the supervising attorney, and that's because the presence requirements that normally apply are only lifted once that condition has been met. So therefore, it is very important that you plan to get all of the documents, the original versions of documents, sent back to you in advance. So you really need to think about how you're going to be doing this. And if you have documents coming from 3 different people who potentially don't work in your office, it can be quite a bit to coordinate, making sure that, if you're sending items by email, that they all have a means and a manner to get them back to you, or that, if you're sending by mail, that you have a way for them, that perhaps you're sending them envelopes or FedExing or planning for people who can't leave a house. So it's just something to think about. And also, very importantly, this is something I don't think we have discussed previously, but try not to get hit by a bus between when your clients sign the documents and when you do, because not really sure what happens there. They're not final until you do the supervising attorney certification. So what is a supervising attorney certification? It's really what it needs to contain is defined in the executive order. You're identifying that the documents you're certifying are true, complete, and accurate originals. You're verifying that the signatures are the original or electronic versions of what you witnessed or what your witnesses witnessed. You're verifying the identity of the signers, their domicile and their residency, their physical location at the time of signing, and then also the identity of the witnesses and their residence. So everything that you're going to be verifying in your supervising attorney certification, you should really be verifying during the signing of the documents. And that goes back to, what David was saying about having people hold up the pieces of paper that they signed so you can verify that it's done properly at that time. If you get something back and it is amiss, like perhaps, you had 3 versions of the will and they signed the second version instead, you can't make your certification, and you're going to have to redo the signing as quickly as possible. So again, just make all efforts that you possibly can to ensure that the documents are properly signed during the meeting. As far as storing the documents, as we said earlier, there are some practitioners who have a habit of keeping multiple originals of the documents. You're going to have to do a separate supervising attorney certification for every document that is an original. So just be thinking about that in advance, just because it is going to make things a bit more complicated for you or take more time to do. And then you can have your clients storing their documents, or you can store documents however you normally would. Just be sure to think about it in advance when you're planning things out. The notary, again, is going to have to retain their recording according to the governor's order, which, as John mentioned, doesn't specify how long the recording needs to be maintained. It seems like 10 years, or planning to do it for at least 10 years is a good start. And then the notary, also for their records, is going to have to reference that the recording was done remotely. So I think that covers everything really for post-execution issues. So that would then be the end of our actual presentation, chat back and forth, and we will be moving to the showing of the remote execution demonstration. Bill, if you can put that on the YouTube. Okay, great. Hi, can everybody see and hear me?
Yes.
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 Okay, great. So today present we have Lynn Sasson in black, David Sessions in a green blue, who is one of my colleagues, and John Lassie in a red plaid, who is going to be serving as our remote notary and witness. All right, today we are here to sign Lynn, my client's power of attorney and will. Our first step is going to be to identify the parties present and the documents that we're going to be signing. And then we will be confirming that everybody can see and hear each other in the appropriate manners. So I'm Leanne Broyles. I'm the supervising attorney today over this remote document execution, which is required for me to serve as a supervising attorney under Governor Hogan's recent executive orders. We also have 2 witnesses present, and one of them is serving as notary. So today, the documents that we'll be dealing with are Lynn's will and her power of attorney. After we sign the documents as prescribed by the executive orders, the documents are going to be returned to me, and I will execute my supervising attorney certification to fully execute the documents. Until that step, documents are not going to be fully executed. So it's very important that everything gets returned to me following today's meeting. Right now, I'm looking around and just confirming that I can see everybody and hear everybody. I think everything looks good. The only thing I can't see is where John will be signing, but we can adjust. That works. Okay, great. And then the witnesses and notaries are going to need to be able to see Lynn signing the documents as well. So we'll go around in turn. I will ask each of you to identify yourself, and then I'll ask for your names, your location, and your state of residence. So starting with Lynn, can you please identify yourself and provide your physical location and confirm your state of residency?
Yes. Hi, Leanne. My name is Lynn Sasson, and thank you all for helping me do this today. I am located in Baltimore at 233 East Redwood Street, and my state of residency is Maryland.
Great, thank you. All right, John, can you please also identify yourself, state your residency and your location? And just because I don't personally know you, can you also hold up your license to identify yourself?
Yes. My name is John. I am located at 7 St. Paul Street, Baltimore. I'm a resident of Maryland. And here is my driver's license.
Excellent. Thank you very much. All right, David, it's your turn. can you please identify yourself, state your residency and where you're located?
Yes, my name is David Sessions. My residency is Maryland, and I am located at 16 Washington Drive, Annapolis, Maryland.
Okay, great. And can everybody please, just thumbs up is good. Can you please confirm that you are able to see and hear everybody else?
I need Lynn to, if she's going to see first, she needs to move the paper closer to herself. Thank
Is
you.
that better? Is that
Yeah.
good? Okay.
Okay, great. All right, so the first document that we're going to sign today is Lynn's last will and testament. Lynn, can you please identify the document that you are signing and hold it up for the camera? As you're doing so, can you please describe the footer of the document, how many pages there are, and which page you'll be signing on?
Yes, Leanne, thank you. I will be signing my last will and testament. This is the first page of the will. It has 2 pages, and it is accompanied by a cover page and a table of contents. There is a footer on the 2 pages of the actual will that says ABC Law PC, Lynn B. Sasson, Last Will and Testament, version 2. And I will be signing on page 2 of the document. And this is page 2 that I will sign on.
Okay, perfect. That matches my copy of the document. David and John, can you please confirm if it matches yours?
Yes, it matches mine. And I also will be signing on page 2.
And yes, it matches mine as well, and I'll be on page 2.
Okay, great. All right, Lynn, since you've already declared this document to be your last will and testament, I'll just need you to also confirm if you're asking for John and David to serve as your witnesses.
I am, and thank you both.
Okay, perfect. All right, so can you please sign the document then so that we can see you signing? Once you're finished signing, please hold it up to the camera so that we can verify you've signed.
I'm also going to fill in that I'm executing it at Baltimore, Maryland on the 28th day of April.
Great, thank you.
And then I'm signing, and here is the signed.
Can you hold it just a little closer? Okay, great, very good. All right, in turn, John and David, can you please sign? John, you can start.
Can you see me sign? Lynn, can you see me
Yes,
sign?
I can, John. Thank you.
I have signed. And there
Great,
is.
thank you. David, now you can go ahead and sign as well. And when you're done, please hold it up for the camera.
And Lynn, you can see it.
I can see you, David.
A little further
Okay,
back.
great.
Hold it back a little. Perfect.
Great. Thank you, everybody. Lynn's will is now signed. It is, as I said earlier, not fully executed yet, and it will not be until I receive all of the original pages back and am able to complete the supervising attorney's certification. So bear that in mind, and please make sure those get back to me as soon as possible. Okay. The next document that we're going to be signing is Lynn's power of attorney. Because this document needs to be notarized, we're going to need to have John acting as a remote notary, and he'll need to maintain a record of the recording for his files. So with everybody's permission, John, I'll ask you to go ahead and turn on your recording.
Lynn and do I have your permission to record this?
Yes.
Yes, I consent.
Recording is started.
Great. Before we get started, for John's notary records, Lynn, can you please hold up your identification for the
Yes,
camera?
here's my driver's license, John.
Do you need it closer, or is that good?
A little closer, please. Up, up. There you go. Now come close. There, good. All right, you got it.
Okay. Great. Thank you. All right, next, Lynn, will you please describe the document that you're going to be signing and hold it up for the camera like you did previously?
Yes, I will now be signing a document that's titled Maryland Statutory Form Personal Financial Power of Attorney. It is comprised of 8 total pages. There is a footer at the bottom of each page that reads ABC Law PC, Lynn B. Sasson, POA version 2. I will be signing this document on page 7, and this is page 7 where I will sign. Can everybody see that?
I can see it. All right, great. John and David, can you please confirm that this document is the same document that you have?
David, after you.
Yes, it is the same document, the same footer. However, I will be signing as a witness on page 8.
Yes, and it's the same document I have, and I also will be signing on page 8 and notarizing on page 8.
Since we've confirmed that everybody has the same document, you can go ahead and sign now. When you are finished signing, please hold it up for the camera so that we can verify.
Here is page 7 that I have signed. Everybody see that?
Yep.
Yes.
Yeah.
Great.
Okay, great. David, can you now go ahead and sign your page 8 and then hold it up to the camera when you're done?
You see that?
Yep.
Yeah.
Okay, very good.
Thank you.
Okay. John can now go ahead and witness and notarize on that same page.
Right. So first I'm going to witness. So there's my signature as witness.
Okay.
Now I will notarize. There is the notarization.
Great. Everybody, Lynn's power of attorney is now signed. As I mentioned previously, it will not be fully executed until I'm able to complete the supervising attorney certification. our document execution for today is now complete, so the recording can be turned off.
Recording is off.
Great, thank you. So thank you to everybody who's here today for participating in today's remote signing. As a reminder, please mail all of the signed original pages back to me immediately so that I'm able to complete the supervising attorney certifications. Once I'm able to go do that, then I will return Lynn's documents to her as we previously discussed, so that she can have everything for her records.
Thank you all for helping me get this done.
You're welcome.
Okay, great. Hi.
You are now live.
Okay, back up. We hope you liked our video. And we're gonna start taking questions now. There are a lot of questions that have been posted on YouTube, so we're gonna do our best to get through what we can. And we're kind of gonna summarize or lump together some of the similar questions that were received. There is a chunk of overlap between some of them. So I'll start off. One of the big question topics that we received is in what capacity can the supervising attorney serve as either witness or notary under the executive orders? So I'll let John address that.
Okay. So the supervising attorney cannot be a witness under the executive order for remote witnessing. However, there's nothing under the remote notarization order that prevents a supervising attorney from serving as the notary as well, as long as they are not also a witness. So that's the basic framework there.
Yeah, and next, as far as available platforms, people are asking what can you and can you not do with Zoom, and then what other platforms are available for remote notary, if there's anything specifically listed, which I think there is. So John, do you want to address that too?
Sure. So the Secretary of State's guidance for remote notarization specifically prohibits Zoom. I don't know whether they'll revisit now that Zoom has addressed their security issues, but for right now, for remote notarization, Zoom is out. They list a number of, as examples, a number of full-blown remote notary service providers that you can look at for if you want to go the whole 9 yards. It'll be required come October. They also list a number of video conferencing platforms like MS Teams, Google Meet, things like that also will work. So you can look; those clearly will be acceptable to the Secretary. Anything like that will be acceptable as long as they meet the U.S. company and length of existence requirements. But again, those examples that are there, they also refer you to the Notary Association website that has other examples and explanations of the criteria.
John, if I could jump in for a second.
Sure.
I think my video turned off, but I think I've looked at some of the other applications, especially the remote notarization ones, and some of them are very expensive, to the tune of like $500 a year or something like that. And I think kind of what we demonstrated can be done actually pretty cheaply. And I think from a practice perspective, may be a lot easier to do for maybe a solo or just because of the cost associated with it.
I agree.
Yeah, and that kind of jumps into another one of the questions or lines of questioning that people are asking. May you pass on the vendor's fee to your client? What's the range of cost, which I think David just covered. And I think people generally have questions about how to price doing a remote signing versus doing a regular one.
With respect to the question of passing on the fee, no, I don't think so. I think you're limited to the $4 fee. That's with respect to notarizations specifically. But beyond that, I don't. Thoughts on pricing?
Yeah, I would agree with the conclusion on passing on the vendor's fee. I think no, you can't do it. As far as pricing something like this goes. I mean, I think it's something you're going to have to think about with your practice area at your firm, and how much is it going to cost to offer these types of services to you versus using a regular signing. Obviously, there's trade-offs with the amount of time that is involved in getting ready for something like this versus maybe not having quite as much time with an actual meeting, and costs that clients are going to understand paying for doing a meeting where they're not coming to your office.
Yeah. On the other hand, sometimes the execution meetings with clients can go very long because you get into discussions with the client about other concerns or issues, next step in planning, and all kinds of related topics. So it is possible that while you're devoting a lot of time to planning for this remote execution, that the actual process may be shorter and may be less expensive than an in-person signing.
Mm-hmm. Okay, another question on notarization. I think I'm lumping together two questions that we receive. One on the definition of immediate transmission and what does that mean? And then when is the actual act of notarization occurring? Are we notarizing the documents after they get the original in the mail, or is the notary notarizing in real time? Hope, do you want to address that, John?
Well, certainly to the point, the term transmit is not defined, so there's no example there. So we've interpreted it as being, as David showed earlier, literally holding up the piece of paper to the camera, and that being effective transmission, and so that the notarization is happening in real time. I think you also could take the approach of mailing it back and forth, but then you would need to do the notarization session as a new video meeting when it arrives at the notary, and it would be an attestation then to the pre-existing signature. Did that cover everything?
Yeah, and I think this goes back to my first comment of it can be seen just as if you were in the same room, right, where you can do something in real time because you can hold it up and you can transmit the document electronically, right, and that's where it's just moved to a video rather than being in the same room.
Yeah, I'm not hearing you.
Leanne, I think you're on mute.
I think I'm back now. Sorry about that. My technological issues are happening. All right, where were we? Okay, so this is a question we're having questions about e-signatures. And how do you witness an electronic signature during a remote signing? David, I think you kind of touched on that earlier. Do you want to?
Yeah, I can touch on it. And again, and this is where I think it gets to your attestation clause and what is required specifically under the law to validly execute a document. And I think practitioners across the board maybe view it differently. Depending on how you interpret cases, but at probably the bottom line, the best practice is the testator watches the witnesses sign and the witnesses watch the testator sign, right? And so I think with the remote clicking, right, it gets a little fuzzy because we have the whole chain of custody, right, where the attorney uploads the document to one of these platforms. The platform notifies the client then logs in and verifies that they're in fact that person, and they click, and in real time that can then notify the witnesses. But I'm not sure under the case law if that's going to pass muster, because again, the way I read case law is the witnesses or the testator has to watch the witnesses sign. And so I would think that would be holding up your device and watching them click. And maybe I'm misinterpreting case law or thinking of it differently, but at the very bottom line, there's supposed to be this visual between the testator doing something and the witnesses doing something. And I think that needs to be captured on video.
I agree with how David interprets that, and that's if I was using electronic signing, I would be doing it the same way as he suggested.
Yeah,
Right.
we all agree with David, and at the moment, I don't think any of us are using that platform for remote executions.
Right. Okay. Next, we have up a question from Brad. What happens if the signer is in a nursing facility and doesn't have access to phone or computer, and no visitors are allowed into the facility? Has anyone encountered this situation? David, are you volunteering?
Let me take myself off mute. I don't know. I was talking to a practitioner from South Dakota, and she was actually mailing like an iPad or an iPhone to a client in a nursing home. I mean, the question is can they receive mail? And maybe you could sanitize the device and everything. You know, I think if they're completely closed off, there's going to be no way that you can sign anything.
Yeah.
But I think as long as you can get them a device and paper through mail, I don't see why you couldn't do that.
If you can get them paper by mail and they can figure out how to use it.
Yeah, that's
another issue. I mean, I think it's great that we have this technology, but there are certain people who unfortunately aren't going to be able to benefit from it just because they might be more limited in their ability to have technology and their ability to understand and use it in a functional way. So it definitely does have its limitations, but at least we have it. All right.
I think it also will depend on the nursing facility. So yeah, some may allow personnel to visit people living there, in which case the personnel may have access to the technology and may be able to help you out.
Okay, question on the recordings. David is asking, will the recording need to be forwarded to the Register of Wills and become part of the final record for a contested will, or if an estate is being examined?
Go ahead, David.
I was going to say, I saw you speaking as well.
I couldn't find the unmute button. That's
I think this gets back to the differences between the notarization requirements and the witnessing requirements. Witnessing does not need to be recorded. And Lynn was mentioning that we had a discussion among ourselves that we wouldn't record any witnessing. And having litigated some cases, there's some interesting recording out there. I don't know if I would feel comfortable recording everything. I mean, it's validly signed, and I think that's what's needed under the law.
Right.
Lynn, you mentioned maybe going back and having people re-execute when we aren't social distancing.
Yes.
What do you think about that?
Well, our plan at the present time is to do that when we are no longer in this crisis, to go back to clients and do live executions with witnesses and testator and lawyer all in the presence of each other. Obviously, that's not going to be possible with every client, but that's something to think about. And if it's something that you're contemplating, you should be keeping a pretty good log of the people that you've done remote executions with. Our thinking is that it just eliminates some of the questions that might arise with remote executions.
Okay, going to jump into a couple questions about the attorney certifications. I have two right in a row. First, so supervising attorney certification shouldn't be signed during the document execution. And then can the certification be done using the same e-sign document so there are no wet signatures? If you are using a wet signature for any of the documents that are being witnessed, you should not be doing the certification as part of that. You need to wait until you get the documents back in the mail, because part of what you're certifying is that the documents attached to the certification are the originals. And I would say probably the same thing, same answer if you are, even if you're using e-signatures, because the certification really is intended to be a certification about the documents attached to your physical certification. So unless perhaps you create a file at the same time of the certification that has everything in it together, I don't think it would be valid. John, do you have any thoughts on that?
Yeah, it might be helpful just to quickly read the definition of electronic signature from the Remote Witnessing Executive Order, which means a visible electronic mark attached to or logically associated with the document and executed or adopted by a person with the intent to sign the document. So it's a visible mark. So you're going to need to be certifying to something visible. So if the final product is a visible something on paper, then perhaps that with all the signatures on it, then perhaps that will work. But my comfort level is to say in these things, I'm going to be doing solely hard copies and solely with my own wet signature.
Okay, and we also have a question, not particularly about estate planning documents, but deeds, and how the remote notarization and witnessing would apply to the execution of a deed.
So I think the remote notarization order applies to any notarization of a document in Maryland. So I think so a deed is fine, as long as the clerk will accept it. No, I don't think there's any problem there. The remote witnessing order is more narrowly tailored to wills, powers of attorney, and advance directives. And so I think there you're limited to those three. There was a question on there about standby guardianships. I do not think the remote witnessing unfortunately applies to those. We may need to go back and explore that.
All right, a question on technology use. Would you recommend to your clients that they use their phone for the video and their computer for the signing and clicking, or vice versa? So I think that would apply if it's an electronic signature. I think that would work.
Yeah, I think whatever they're comfortable with, as long as everybody can see what's going on.
Yeah, and you might, if you're using an actual computer for the signing and clicking, you might have a bigger screen that you can see better on the camera. So I think that would make sense, but really on a practical level depends on how it's all interplaying.
Right.
Well, and I think this goes back to what Lynn was saying, is making sure that you try all of this before you do it with a client, and maybe even doing a dry run with a client. That, you know, if you're signing documents with someone who's 80, you know, I'm there's some very technologically savvy 80-year-olds out there, but some of them, you know, have trouble pushing buttons or something like that. And I think going through that process is important before you get to the actual documents.
I am trying to get through to find some additional questions. I think there's a lot of commenting back and forth on the YouTube channel, which is great that it's very interactive. But just trying to find something that we can answer for you. Let's see. There's some questions about how can a Maryland notary only notarize the document if the signer is a Maryland or resident who is located in Maryland. And I believe there was another question about if you're a Maryland notary who's not in, or can you notarize something for an individual located in another state? Kind of the same thing. I think the answer to that is yes, that the person for whom you're notarizing has to be in Maryland at the time. Is that?
Well, I think the existing notary rules on that apply. So I don't think you're allowed to. I'm not a notary. I only play one on TV, but I don't think you're allowed to notarize a document if you're out of Maryland. So I think those same rules would apply.
Yeah, I think that's generally the case for, I suppose it depends on the laws for serving as a notary in the state where the person is located at the time.
Right.
Okay.
Can I jump in with one?
Yes, please do.
Okay. So the question is, will the original document certified have to include all the pages of each document signed? And the answer to that is yes. That's part of the certification, is saying that it includes as a full complete copy and includes all the pages.
Okay, here is a question on our video. If we can repeat the platform that we were using for the sample session.
Oh, the platform is MS Teams, Microsoft Teams.
Yes. Question from Ethel. Do the witnesses have to have a full version of the document that they are witnessing?
Yes, because the witnesses have to be able to identify that they have the same document that the testator has. So ordinarily, in a live execution, the witnesses would just see the page that they're signing. But in the remote execution, we have all concluded that the witness needs to have a copy of the complete document and be able to identify the footer, the number of pages, the page the testator is signing on, and the page the witnesses are signing on.
Leanne, if I could go back to the platform question, I did some test runs with GoToMeeting, which worked really well. However, you had to buy into a higher subscription if you want them to be able to record the video. And so that's where MS Teams was a little bit easier on the recording, because if you have an account with MS Teams, they allow you to do it anyway, or a subscription to Microsoft 365. Some other ones that we've used include Google Meet or Google Hangout. But again, sometimes the problem with that is whoever's speaking, the video flips to that person, and so you can't see all four people at the same time. But GoToMeeting was another helpful platform. It's just you need to pay a little bit more to get the recording service with it.
A question from Alec asking if the testator and the two witnesses are physically together, as if they were in a critical care facility, can the supervising attorney supervise by audio phone? I think this gets kind of to the question of whether that is a remote signing or remote witnessing to begin with. I think if you have witnesses present with the testator, you are not relying on the order at that point.
You don't need a supervising attorney.
Right.
However, if the scenarios change slightly and you've got the principal and one witness there, and then a second witness is coming in remotely, then yes, you need everybody needs to be able to see everybody else.
But also, I mean, if you did draft documents, right, there's no reason why you can't do a video call and watch them signing and making sure that you know that the three of them are doing it properly under the law. I mean, again, it goes to managing the process. You're the lawyer that drafted the document, and certainly you probably want to be there to be able to watch them sign and make sure that it's going well.
Right. For all the reasons that you rarely send documents to clients to execute on their own because they never do it correctly. So, you know,
Exactly right. Exactly.
on the phone or monitor or on some platform where you can see what's going on and at least direct the process, but you're not officially using the remote execution rules.
Question about the final package that is the certified copy of the original document. So we're being asked if the final package that's being produced is 3 copies of the will as received from each participant, which I assume means the witness's full copy as signed, the witness's full copy as signed, and then the testators all being combined into one package, or are we doing it differently than that? So I can answer how I think it should be. I think that you would have the that it doesn't require 3 full copies of the will, but requires the full will signed by the testator and then the witness's signatures afterwards in a package that has the supervising attorney certification on top.
Yeah, it's essentially a counterpart copy where people are signing different documents, but then you put all the signature pages together.
I'm still, if anybody else is able to pull questions out to ask, please feel welcome to do that. I'm trying to.
Do the witnesses have to mail back the entire document or just the witness signature page? I personally, we hadn't talked about it, but I personally think the signature page is sufficient as long as they verify that it was the entire document.
Yeah, unless perhaps you have somebody who's initialing on each page of the document and you need to get all of that, which might be a reason to not do that. As a practical matter, we have been asking people to return the full document to us, but I'm not sure that you actually have to do it that way for it to be valid.
Let's see, is there any way it could be valid for a blind client to do remote execution, assuming he or she has somebody helping with the technology aspect of it? I don't see why not. People can sign you could do a directed signing as long as people are in the right place. I don't see why it wouldn't work.
We have a question on the international will certifications from Lee Alexandra. The international will certificate requires the supervising attorney to certify the signing occurred in his or her presence. Do you know if remote presence will qualify? The convention was passed. I don't think that remote executions are contemplated. I think that these international will certificates are adopted by state statute. So if presence is defined in the statute, or the term presence used in the statute, then I would think that the order would impact it to allow for remote witnessing, but I'm not 100% sure about that. We have not actually looked at it.
Yeah. Yeah, Lee, I don't think we know the answer to that.
Yeah, we need to double check on that one.
I saw a question relating to the notarization of trusts and how the executive orders apply to trusts. From my understanding of the law, really under Maryland law, you don't need a notarization for a trust.
Right.
But other jurisdictions do require it. And so if you do have a mobile client, maybe you do want the notarization. But I believe the notarization procedure that we've been talking about would apply to a trust just fine.
Right.
For simplicity's sake, I have been dropping it, even though we generally do notarization.
Well, I think we all, even though it's not required, we've all always done it. And there's also expectations on the part of financial institutions or others that your document is going to be notarized. So David, like you, I've been dropping the notarization requirement on documents on trust that I know are not going to own real estate, but I've also contacted the financial institution first and said, here's what I'm doing. Are you going to object to this or create obstacles? And my experience has been that people have been pretty cooperative because everybody understands that these are challenging times.
And it's always an option to have them sign the document, send the original back to you, and or even a copy at that point, and then get the notary on a remote link and do the remote notarization as an attestation that way.
So looking at the time, and I don't know if Andrea was unmuting for that purpose. I think it's 2:30.
That's correct. Thank you so much. I really appreciate our panelists. Thank you, Leanne, for leading us off and for handling kind of trafficking, keeping track of the traffic of questions. We really appreciate the Estates and Trust section pulling together this presentation. We thank everybody, several hundred that joined us for today's webinar. Our panelists, Leanne Broyles, John Lasley, Lynn Sasson, and David Sessions. Appreciate your time and effort on this presentation. We hope everybody finds these presentations to be timely, and the MSBA is pleased to be able to bring them to you. If you are aware of topics that you would like to have covered that we haven't touched on yet, please feel free to reach out to me, and we'll try and pull together the information that you feel like you need. With that, we will close today's program, and thank you again for your time. Take care, everybody.